What is up, YouTube? This is AmK at Purple Sky 11, and this is part 22 of my deep dive series into the Benoit police files. In this video, we're going to take a look at the 2003 Family Violence Protective Order that Nancy was granted against her husband, Chris Benoit. But before we get started, please remember to like, comment, and subscribe. Hit that little bell so you receive notifications when future videos drop. And share this with anyone you feel might be interested, as this channel is being shadow banned by the YouTube algorithm. Please keep in mind this video is part of a series, and if you'd like to catch up, you can find a link to the full Benoit playlist down in the description box. And if you like what you see and would like to support the channel, you can find a link to my Cash App in the description box as well. Contributions of any amount are welcome and greatly appreciated. A huge thank you to everyone who contributes. I couldn't be doing this without you. Now with all of that out of the way, let's get into this video. Before we get into today's content, I have an exciting announcement I can't wait to share with you. On October 21st, 2021, I published the first video of what would turn out to be an extensive deep dive into the police files and evidence pertaining to the 2007 murder-suicide of the Benoit family. And now, almost a year later, we are finally nearing the end of the documents. It's been an amazing journey, and I am eternally grateful to all of my amazing viewers who were with me along the way. But dry those teary eyes, folks, because every ending leads to a new beginning, and I am excited to announce the subject of my next series, drumroll please, Owen Hart. I have 73 pages of documents from the Kansas City, Missouri Police Department, and I am awaiting a response from the same jurisdiction about any post-mortem documents, so we'll see how that turns out. But I am really looking forward to digging into some fresh documents. And I hope that if you enjoyed the Benoit series, you'll consider sticking around for another adventure. And now let's get back to the Benoit video. Okay, so now I want to look at this 2003 protective order that's included in these documents. If this would have been 2005, 2006, or 2007, I would have included this earlier in the series. But this was in 2003, and there's nothing, no protective orders or no court incidences after this. So you could argue in court that that would be an indication that things had been better with the Benoits as far as their relationship. And especially if you consider the fact that the evidence shows that they were cooking out that Friday evening of that weekend. And also considering the text messages with Chris Benoit texting, "I love you, I'll see you soon," to Nancy, that you could argue in court that things had gotten better with their relationship. This I didn't feel was such extreme evidence, so that's why I'm doing this now, instead of earlier in the series. So this is a 2003 protective order, and you can see here the stamp. This is dated 2003, May 12th. The Superior Court for the County of Fayette, Nancy Benoit, petitioner, and Christopher Benoit, respondent. And this is a family violence ex parte protective order. According to legaldictionary.net, ex parte is a term used in law to refer to court proceedings for the benefit of one party to a controversy without the other being present, and that this is an exception to basic court procedure, which requires that both parties be present at any judgment or proceeding. So in other words, this being an ex parte family violence protective order, that means that Nancy herself was in court, that Chris Benoit was not there to protest to this or to introduce his own evidence to the contrary. This would just have been Nancy and her attorneys and a judge. And I'm not trying to suggest that Nancy was doing anything inappropriate or shady by doing this ex parte. I'm not trying to suggest that in any way. I'm only trying to explain what these terms mean. Most of the time when an order is granted ex parte, it's because the judge felt there was enough evidence to prove that additional harm could come to Nancy and Daniel if Chris were informed about this hearing. And the courts do this to protect the petitioner from further abuse, because this way, the protective order is already active by the time the respondent finds out about it. So this says the petitioner, having prayed pursuant to OCGA subsection 19-13-1 et sec, which is et sequentia, which just means and the following or and others. So this is saying that under that specific code of law, that a protective order be issued and alleged that respondent has committed acts of family violence and that petitioner is in reasonable fear of the petitioner's safety and the safety of petitioner's children, and it appearing to the court that probable cause exists that family violence has occurred in the past and may occur in the future, it is hereby ordered and adjudged, number 1, that these proceedings be filed in the office of the clerk of this court. Number 2, that this order applies in every county throughout the state, and it shall be the duty of every court and every law enforcement official to enforce and carry out the provisions of this order, pursuant to, and then it's another law code, law enforcement officers may use their arrest powers pursuant to these codes of law to enforce the terms of this order. Number 3, that a copy of this order be given to law enforcement and the respondent be served with a copy of this order and petition for temporary protective order instanter. And that's just a legal term that means immediately or without delay. Number 4, that the respondent, that would be Chris Benoit, appear before this court on the 6th day of June 2003 at 9:00 a.m. in Room A of the Fayette County Courthouse to show cause why the requests of the petitioner should not be granted. Okay, so this protective order was filed ex parte on May 12th, 2003. But then Chris Benoit, as the respondent, would have the opportunity to go to court June 6th, 2003, to give reason why this petition should not stand. But in the meantime, the protective order was granted to protect Nancy and Daniel. And number 5, that the respondent is hereby enjoined and restrained from doing or attempting to do or threatening to do any act of injury, maltreating, molesting, following, harassing, harming, or abusing the petitioner and or the minor child in any manner. Respondent is not to interfere with petitioner's travel, transportation, or communication. Respondent shall not follow, place under surveillance, or contact the petitioner at any place of the petitioner for the purpose of harassing and intimidating the petitioner. Now, for this, I don't know if this is standard language for these ex parte protection orders, or if these stipulations were written out specifically because they were complaints that Nancy had. I know when we looked at the statements from the neighbor and from one of Nancy's friends, which you can see in part 3 of my series, they were saying that Nancy felt that Chris was being really controlling, telling her which route to take when driving to certain locations and hiding the car keys and things like that. So I don't know if that would have something to do with that. But keep in mind, this was back in 2003, and as you'll see further down here, this protective order was dismissed in September of 2003. And as far as I can tell, I don't think there were any additional protective orders filed between 2003 and 2007. So, not sure how much from the police documents we can correlate to this specific order. Number 6. That the respondent is enjoined and restrained from doing or threatening to do any act of injury, maltreating, molesting, harassing, harming, or abusing the petitioner's family or household. Number 7, that this court determined that it had jurisdiction over the parties and the subject matter under the laws of the state of Georgia, and the court ordered that the respondent be given reasonable notice and opportunity to be heard sufficient to protect the respondent's due process rights. This order shall be presumed valid, and pursuant to 18 U.S. Code subsection 2265A, shall be accorded full faith and credit by any other state or local jurisdiction, and shall be enforced as if an order of the enforcing state or jurisdiction. That just means that Benoit has been given notice to be heard by the court, but that until then, this order is valid in all jurisdictions, whether in or outside of Georgia, and that those jurisdictions should enforce this order as if it were an order of that state. By including this in the order, Benoit couldn't take Daniel out of state and file an order for custody in that state because this order would supersede that order or any other order. Then it says only the following that are initialed by the judge shall apply. So we have number 8, that until further order by this court, petitioner is awarded sole and exclusive use of the family residence at 304 Pemberton Court, Peachtree City, Georgia. Number 9, respondent is ordered to leave the family residence immediately, and law enforcement, looks like Peachtree City Police Department, sheriff or police department, is ordered to assist petitioner in returning to the family residence and the removal of the respondent. Respondent is to immediately surrender to law enforcement, Peachtree City Police Department, sheriff or police department, all and any keys, garage door openers, and other security devices to the family residence, and law enforcement is to ensure that these are given to the petitioner. Number 10 is not checked, so I'm gonna skip those. You can pause and read if you want. Number 12, respondent is ordered to stay away from petitioners and petitioner's minor child residence at 304 Pemberton Court, Peachtree City, Georgia. Number 13, that until further order of this court, respondent is restrained and enjoined from approaching within 100 yards of petitioner and or petitioner's minor child. Number 14, respondent is ordered not to have any contact, direct, indirect, or through another person with the petitioner by telephone, pager. This is really that old. Pager. Wow. Fax, email, or any other means of communication except as specified in this order. Number 15, that petitioner is awarded temporary custody of the minor child, namely Daniel Benoit, date of birth February 25th of the year 2000, and respondent is ordered not to interfere with physical custody of the child. And then it says, initial here only if respondent is awarded temporary custody of the child. Well, and that is checked there. So the respondent would have been Chris, so he would have been awarded temporary custody of the child. But then it says here that the respondent is not to have any contact? What? This entire document is weird like this. Like, apparently Chris was violent enough for Nancy to be granted this ex parte restraining order for herself and Daniel. It says Nancy is awarded temporary custody. Then it says Benoit is awarded temporary custody and gives a child support order. It gets even weirder further down, as you'll see. Then this isn't checked, but it's filled in, number 16 here, that respondent is ordered to pay temporary child support for the amount of $3,500 every month, beginning May 15th of 03. All payments shall be made by mail directly to the petitioner. And then here, now this is checked, number 17. That the respondent is ordered to pay temporary support for the petitioner in the amount of $5,000 every month beginning 5/15. So does that mean that while this order is in effect, Benoit had to pay Nancy $3,500 a month for child support and $5,000 a month for alimony type payments? Whoa. And a judge actually approved this ex parte, so without hearing from Benoit himself. What the actual... Number 18, that respondent, only when accompanied by local law enforcement, shall be able to remove his or her clothing and personal items from the residence as follows, upon providing petitioner with 24 hours advance notice of respondent's intention to retrieve such items. So this is pretty strict. I don't know what kind of evidence Nancy put forth to get this kind of order here, ex parte even. I don't know. Number 19, that both respondent and petitioner are ordered not to sell, encumber, trade, damage, contract to sell, or otherwise dispose of or remove from the jurisdiction of this court any of the property or pets of the petitioner or joint property or pets of the parties, except in the ordinary course of business. Number 20, that both respondent and petitioner are ordered not to disconnect or have disconnected the home utilities, change or have changed and or cancel or have canceled auto, health, or life insurance for respondent, petitioner, and or petitioner's children, or interfere with respondent's, petitioner's, and or petitioner's children's mail. Number 21, that petitioner is awarded temporary sole possession of the vehicle. A Hummer, year 2003, color red. Respondent shall immediately surrender all keys, proof of insurance, and registration to this vehicle to law enforcement, and law enforcement shall immediately turn over said items to petitioner. So they even took away Benoit's access to the only vehicle they had at the time? What the hell? See, I'm sorry, but I don't feel like any woman should have the right to take essentially everything away from a man. His home, car, his money, children. At least not without even allowing the man to speak in his own defense. And I am saying this as a woman who has seen her fair share of custody arguments in and out of court, both with and without police involvement. Okay, so these aren't checked, so I'm gonna skip over them. Feel free to pause if you'd like a closer look. And then it says, so ordered this 12th day of May, 2003. So that's damn. And they ordered for Benoit to pay $5,000 a month child support based on just this ex parte, beginning May 15th. So that was 3 days after this order. Holy crap. She must have had some pretty good evidence to be able to get this order granted ex parte. Unless this judge had a history of dealing with the Benoits, that the precedent for abuse had already been set. Or unless this judge was a family friend, or maybe simply jaded by the name Benoit. I don't know, that's research for another day. Then there's this here, this is dated June 23rd, 2003, and this is the final protective order. So this now would be the judge's ruling after hearing from Benoit and after any legal counseling of the parties involved, and so this is their final agreement. It says, civil action file, family violence 6-month protective order. You can see top left here, Nancy Benoit plaintiff versus Christopher Benoit defendant. This says, a hearing was scheduled in the foregoing matter on June 6, 2003, in which plaintiff asked the court to continue the temporary protective order entered in this court on May 12, 2003. Plaintiff and defendant appeared along with their respective counsel, and both parties, having reached an agreement on the issues, request this court to enter an order pursuant to that agreement. Therefore, it is hereby ordered and adjudged. So then these following items then would have been agreed on by both Chris and Nancy Benoit. And these are the stipulations, basically the rules that the judge ordered them to follow. Number 1, the defendant, which would be Chris Benoit, in the course of his employment, travels extensively. The defendant may, with the express written permission of the wife, have unrestricted use, along with the plaintiff, of the family residence at 304 Pemberton Court, Peachtree City, Georgia. Wait, huh? So she needs to have this protective order extended, but she's agreeing to give him unrestricted use along with her of the family residence? Interesting. It goes on to say, during those periods of time that the plaintiff gives the defendant permission to stay at the family residence, she agrees to execute a document showing that the defendant has plaintiff's authority and permission to be there. Defendant may not stay at the family residence unless the plaintiff executes said document. What the hell? Is this normal for a protection from abuse order, that the alleged abuser can come and go as he pleases as long as he has expressed written permission from the abused? Then they can be together unrestricted? Considering how expertly manipulative abusers can be, that seems a bit dangerous. I don't know. Number 2. During those periods of time that the defendant is in Georgia, plaintiff agrees to allow defendant reasonable, unlimited, and unsupervised visitation with the minor child of the parties, as may be agreed to by the parties. Okay, let me get this straight. Defendant and alleged abuser, Chris Benoit, travels extensively, but when he's not traveling, it's fine if he has unrestricted use of the home, along with the plaintiff, Nancy Benoit, alleged victim of said abuse, as long as she signs a document saying that she agrees to it. And during those periods of time that Nancy allows Chris unrestricted access to the residence while she's there, she agrees to allow him reasonable, unlimited, and unsupervised even visitation with the minor child. Is it me, or does this just sound like how it would normally be? Anyway, anyway whenever Benoit would be home and not traveling. Free reign of the house, time with his child. The only difference being that with this order, he needs Nancy's expressed permission to do those things. I don't know. I don't want to say too much in this one because I don't want to get accused of being insensitive, trying to make Nancy look bad or anything, so I'll leave it at that. Number 3, that plaintiff and defendant are hereby awarded temporary joint custody of the minor child, namely Daniel Benoit, date of birth February 25th, 2000. The primary physical custody of the minor child shall be with the plaintiff. Number 4, during the pendency of this order, all household and business-related bills, including personal expenses of the wife, as well as the wife's Fleet Finance MasterCard, shall be paid by the defendant. Okay. Oh, crap. Wife shall provide the monthly statement for this account to husband on a timely basis. Additionally, during the pendency of this order, defendant agrees to pay plaintiff the sum of $2,500 per month starting on the first day of July 2003. No comment. Number 5. If both parties agree, the defendant may remove any personal property of his that is at the marital residence. If the parties do not agree, then the defendant, only when accompanied by local law enforcement, shall be able to remove his clothing and personal items from the residence upon providing plaintiff with 24 hours advance notice of defendant's intention to remove such items. Number 6. Both plaintiff and defendant are ordered not to sell, encumber, trade, damage, contract to sell, or otherwise dispose of or remove from the jurisdiction of this court any of the property or pets of the plaintiff or defendant, or the joint property or pets of either of the parties, except in the ordinary course of business. Number 7. It's going on to the next page here. Both plaintiff and defendants are ordered not to disconnect or have disconnected the home utilities, change or have changed, and or cancel or have canceled the auto, health, or life insurance for either of the parties and or the minor child of the parties, or interfere with each other's mail. Number 8. The plaintiff is awarded temporary sole use of the family vehicle, a 2003 Hummer. Number 9. This order shall continue and remain in effect for 6 months from this date, or until such time as the petition is dismissed or superseded by an order from a court of competent jurisdiction. So ordered this 27th day of June 2003, the Honorable Pascal A. English, Judge, Superior Court of Fayette County, Georgia. Read and expressly agreed to by, and here you can see the signatures, Nancy Benoit, Chris Benoit, and their attorneys, right there. Wait, how can it be scanned on 6/23 if it's ordered the 27th day of June? Or is this supposed to be 23? I'm not sure. But then here is the filing fees, I guess, and things like that, right here. And you can see that down here, it says that by September 8th, 2003, these orders we just looked at were dismissed. So it was only less than 3 months that this order was in effect. 4 months if we include the time frame with the ex parte protective order. So in other words, Nancy was granted a family violence 6-month protective order that she then dismissed after only 3 to 4 months. And eerily enough, this family violence protective order had been granted to Nancy on June 23, 2003. Exactly 4 years later, she would be tragically murdered. Domestic violence is no joke. I don't care who you are or how bad a day you think you had, there is never an excuse or reason to violently put your hands on anyone. And there's also no reason good enough to stay in a relationship with a violent partner. Nobody can see what goes on behind closed doors. If you or someone you know is a victim of domestic violence, I encourage you to reach out to the National Domestic Violence Hotline at 1-800-799-SAFE. or chat with someone online at thehotline.org. You are strong enough to take this first step, and you don't have to do it alone. Reach out today. And that's all I have for you today. If you enjoy the content and would like to support the channel, contributions of any amount are welcome and can be made at the Cash App link in the description box. Please feel free to share any thoughts and hit that thumbs up button and share these videos with anyone you think might be interested in checking them out. On a personal note, I just would like to add that it was 11 years ago this month that my son and I had the opportunity to meet Rowdy Roddy Piper. Rod was super kind to us. He taught my son how to throw a punch, and he always gave the best hugs. We miss you, Rod. Thanks for everything. And in case you didn't know, They Live is one of the greatest movies of all time. If you haven't seen it, why haven't you seen it? What are you waiting for? Go watch it. Now. Go now. As always, thank you so much for taking the time to hear what I have to say. This has been AmK at Purple Sky 11, and I hope you have a great day. Bye.